you for the invitation to present today. So I'm Giselle Roberts. I'm the Director of Research and Innovation at Laurentian University, where I provide, I have sort of administration over sort of the research that takes place at university, the contractual side of things and the relationships, but also supporting innovation and entrepreneurship. I've been doing this for a number of years and sort of consider it the fun part of my job. So I'll share my screen and here we
Yeah.
go and switch over to full screen. Can everybody see that?
Yes. Yeah.
Excellent. So I'm going to go through this fairly quickly. Um, I'll share the information with you after. There's a number of links that are embedded in here, so everybody, like I said, I'll go through it quickly. You can read it after, but I'll try to hit some of the high points. So here to talk about intellectual property. So what it is and why it matters, and what I'd like to do is give an oversight of the basics of intellectual property and some of the resources that you can find online for educational purposes, and also the agencies that provide resources to help you protect your intellectual property. So first of all, a disclaimer, it's for information purposes only. I'm not a patent agent or a lawyer, so this content should not be considered legal or professional advice. And I would advise anybody, to consult a qualified professional when they're considering investing into protecting their intellectual property. So the overall objectives is to define intellectual property according to the various types, identify and evaluate the key factors to consider when commercializing IP, and also to, as I mentioned, identify and underscore sort of the key resources that provide IP education and support for the protection and commercialization. So informally, what is intellectual property? It is simply defined as any form of knowledge or expression created with one's intellect. So this includes computer software, trademarks, literary, artistic, musical, or visual works, or even simply know-how. Formally, it's an intangible asset, so something not necessarily that you can hold in your hand, but but what it is, it's an asset that can be protected by formal legislation. And so those are rights granted by the federal government. So it could be a patent, trademark, industrial design, or copyright. But intellectual property can also be an asset that provides national and international value without being protected. So that's know-how and trade secrets. So the first one that I'm going to discuss briefly is a patent, and that's an exclusive national right to your invention that is granted to you by the government. It lasts for 20 years from the date that you file your application. One thing to keep in mind is that it is published, and that is 18 months after you filed the first application. So in that application, you will have to disclose what that invention is. So it is, a lot of people unfortunately think that a patent protects their right to an invention, which theoretically it does, but it also discloses that invention. So you're letting people know how you created it and the steps that people can go through basically to practice your art. A patent covers any new invention and or any new useful improvement to an existing invention. It must be novel, so new, have utility, so you need to be able to do something with it, and not obvious to a person skilled in the field of the invention. So when you go through the prosecution, what may not be obvious to you may be obvious to someone who's skilled in the trade. Copyright is the sole right to produce, copy, or translate literary, artistic, dramatic, or musical works, including computer programs. So it does not protect your idea, but it's the expression of that idea, such as a song or some other a computer program. So not the idea of what it does, but the actual expression of that idea. So with copyright, it comes into existence automatically when the work is created. And it lasts for your lifetime plus 70 years. So what you need to do, you can file formally, and I'll give you a list of resources at the end where you can file for a copyright or a patent. But the difference with copyright is that you can put, if you're creating a visual, a website or publication or some other form of you know, visual, kind of work, then all you need to do is to put the copyright notice at the bottom, the year, and your name. So the author of a work is the first owner of that copyright. However, when a work is created by an employee in the course of his or her employment, in the absence of an agreement to the contrary, the employer is the first owner of the copyright. So if you're working for an organization, I work for Laurentian University. When I present, the first slide that I had, I put a copyright at the beginning of the document, but it's because I work for Laurentian and I do this work for Laurentian, they own my copyright. One thing that I want to highlight with moral rights, they're associated with a copyright, and this is the right to attribution or association and to your work. So to be associated with it, you have that right, or you may wish to be anonymous, but it also the right to the integrity in your copyright. And moral rights cannot be bought or sold. So you can waive your moral rights. And I always like to give this example of moral rights. So a few years ago, an artist created, this is an image taken at the Eaton Centre in Toronto, and there are geese sculptures that are hanging from the ceiling. So these are a work of art. And at one point, the Eaton Center for Christmas, during the holidays, put little bows and hats on the geese to decorate them for Christmas. So they basically turned them from a work of art into a Christmas decoration. The artist had sold the items to the mall, to the Eaton Center, but they had not waived their moral rights. So they sued the Eaton Center and won because they had changed the integrity of the product that was sold. Trademarks are letters, words, sounds, or designs that can distinguish your company's goods or services from those of others. So they can be registered for use in Canada for 10 years, and those can be renewed. One thing to note with a trademark is that you need to defend it or you will lose it if it can be demonstrated that someone infringed on your trademark, but you didn't defend it. So a very local example of that is there's a brewery here in Sudbury called Stack Brewers, and they were selling the Angry Moose and the Friendly Moose beer a few years ago. And there's a brewery in Nova Scotia called Moosehead. So because you're dealing with beer and moose, so they sent a cease and desist letter basically to Stack Brewers to say, you're infringing on our trademark. Was it truly an infringement? Hard to know. You would have to go to court really to get a decision on that, but they had to defend it because otherwise then they would open themselves up to other infringements in the future. And Stack Brewery just simply said, okay, no problem, and they stopped selling those types of beer. An industrial design relates to the shape or configuration of a product. So kind of like the Coke bottle has an industrial design. So it's look, not its function, and it must be registered for protection. So in Canada, we'll give you up to 15 years of protection. Like a patent, it must be new and unique, so not disclosed. And I'll talk a little bit about that for patenting in a minute. But it does not require a functionality like a patent does. So we'll go back to patenting and commercialization because that's often a topic of interest to innovators. So these are the different these are the different factors that you need to consider when you're patenting, and I will go through each of these individually. So inventorship. So an inventor is a person who contributes to the inventive concept and to at least one claim of the patent. So when you're looking at patent applications, you will see that, there's a title, there's an abstract, and as you go through the document, there will be claims, which specifically identify what the patent does. So you may have, I'll use the example of a laboratory in a university, right, where you may have a faculty member who's working with students. The students are working under the direction, most of the time, the students are working under the direction of that faculty member. So they may not necessarily be inventors because they're following direction from their supervisor. So they're not necessarily um, enabling the invention. So you wouldn't want to name them on that patent if they have not contributed to those claims. Inventors can be two or more individuals who have collaborated on an invention through a joint partnership. It is not the same as authorship. When you're looking at publications, you know, you don't you don't necessarily you can't consider it in the same way. Um, but even though you may not want to include, people, individuals who did not contribute to the inventive concept, you also want to make sure that you do capture all of those inventors because not including them can be very costly. And if you were challenged by someone who contributed to that invention, it could invalidate your patent. And patents are very expensive, and I'll go through that shortly. Ownership throughout the world, patents are granted on a first to file basis. So in the absence of any agreement to the contrary, you can file a patent and become its owner. So a couple of things to unpack there is that, it's first to file. Previously, we had a system in Canada which was first to invent. So someone could file after you, but if you can demonstrate that you had developed that invention prior to that filing date, then you would have been then you would have had the priority for that patent. But now it's on a first to file basis. And the other thing is that if you're working with someone else on something, and there's no agreement about who owns it, or if you invent something yourself, but working with, a company, unless if you are truly the inventor, you can go and file that patent if there's no agreement that specifies who owns that patent. So always make sure that, you have agreements in place to specify who owns the intellectual property. Disclosure. So in Canada and US, there's a 12-month grace period where, if you were in a pitch competition and you disclose your invention, then you would have 1 year to file that patent, even though you've disclosed it publicly. One thing to note, though, even though there is that one grace period, that's only Canada and US. So if you have an invention that you want to patent globally and different jurisdictions throughout the world, you won't be able to because you've disclosed it. So you could file in Canada and the US, but not anywhere else. One thing that I always recommend is the use of confidentiality agreements if you are disclosing, to someone else. Again, it's just to protect yourself until you file that patent, right? And there's different files of patents, and again, I'll go through it shortly. But what's called a provisional patent, which could be your first patent application, it's a 12-month application, and if that you can allow that application to expire and it's never disclosed. So even if you file a provisional patent, I would still recommend that you use confidentiality agreements because you could allow that patent application to expire and then refile a year later the same technology. Sometimes, you just don't have the resources to keep that patent application going. You may be looking at, investments and, you've filed that to sort of put, the line in the sand, but then you don't have the resources to continue, so you can allow it to lapse. So that's why those confidentiality agreements are important, because if you were to allow it to lapse, then whoever you disclose it to theoretically could file a patent on your invention. The costs, again, patent protection is by country. There is no global patent that will protect you everywhere in the world. And so you have to file in each of those countries where you want protection. A rough rule of thumb, and these numbers are a little bit outdated, so I'd have to look at them again. But you're looking at $15,000 to $20,000 to issue in Canada or the US, and then add an additional $5,000 per country named and translation fees. So basically, you can take the same application. A lot of the cost is drafting that application initially, so you can sort of take that, copy and paste it, let's say, into other jurisdictions. And why it's so expensive is that you're looking at the filing. So, when you file with the whatever patent office that you're using, um, there's the filing fees, and then there's maintenance fees, and then there's examinations and issues. So they will not just automatically say this is a great invention and grant you that patent. You go through an examination, a defense of that patent. And there it can be a lot of back and forth, and most people use patent agents, and that gets very expensive. And then there's annual maintenance fees, and you even pay to have it issued. So these are all costs that go into it. So you've got lawyers and patent agents. The other cost you need to consider is the cost of defense against infringement. So if someone infringes on your patent, the government will not protect you. You know, the government gives you the right to be the exclusive sort of manufacturer of a product or whatever through a patent, but it does not protect you against infringement. So you may have, maybe you've spent $20,000 on a US patent. If someone infringes, you have to take them to court, and that gets very expensive. The types of applications, so I referred to this briefly, the provisional patent application. So it allows you to set your priority date, and it will expire after 12 months if you don't have the resources to continue the application. A PCT is it's an international application that allows you to seek patent protection for 18 months. So or you could skip the provisional and go straight into the PCT, and that gives you 30 months. In more than 150, so you've got the one application, and then it gives you 30 months to decide where you want to go. So I think that's where some of the confusion comes in, where people think that, this is a global patent, but no, you have to decide when that period of time expires, which countries you're going into. And again, national filings by country where protection is required. And keep in mind that um, your application is published, so you're enabling that invention. And if you do not have protection in a certain country, then you can't sue people for infringement if they use your patent. Couple of websites just to give you an overview, the different, before you file a patent, you really need to look at, what's been created already so that you're not infringing on someone else's patent. And also to make sure, like, even if a patent has expired and you're not necessarily infringing, is it new, right? Is this a new invention? So these are the different websites that you can use to search for prior art. Um, what I would caution against is using AI for some of your searches, especially if you're putting in elements of your invention. Unless you are paying for, ChatGPT or some other AI platform, you have to realize that your information could be used to sort of inform that platform. So not necessarily a good idea to use AI to sort of evaluate your technology versus another. And then finally, just some educational resources. There's some really good programs out there that provide um, online courses. Um, you know, just some very basic stuff. SIPO, which is a Canadian Intellectual Property Office, has really, really great resources, and it's broken down by types of intellectual property. I highly recommend that you look at it. Intellectual Property Ontario. IPON, they have a foundational IP course. One that I highly recommend is the University of Toronto Intellectual Property Education Program. We offer this now through Laurentian on the D2L platform. And then there's also an IP Foundation series available through ISED, or which is the Innovation, Science, and Economic Development, so the Government of Canada. There are also some links to programs that can actually support the cost of filing for intellectual property if you formed a company. So there's funding available from IPON, so which is the first link, and then also the IRAP, which is the Industrial Research Assistance Program for companies. So that's just a very quick overview of, what intellectual property is, educational resources, and also different programs that exist to support you. I know that was very quick and a lot of information. I will make that slide deck available to participants, but happy to take any questions.
Thank you, Giselle, for the presentation. It was very practical and insightful. And I hope you gain a lot of information. And if you have any question, you can start asking now. We only have 5 minutes left. Okay, Giselle,
Yep.
for
Oh,
okay, there's a question here. Let me open chat now.
yep. Trademarks can be done outside of Canada. You would have to, again, it goes by jurisdiction, right? So, um, you would have to look at the various countries where you want protection, same as patenting. Again, I highly recommend the SIPO website. It is very helpful, and there's some great tutorials on there on the different topics. So have a look at that website. You'll have all the links in the presentation.
So, what are the first step of IP protection you recommend for a small business?
Sorry?
For a small business,
Yep.
what type of IP protection do you recommend?
It depends on, certain things can be patented, some, others can't, right? It's through copyright. It depends what type of product that you're developing or service or again, like it's very broad, right? I remember being at an event where someone was talking about special design for clothing, like protective clothing, right? That's not necessarily, unless it's actually the material that's being manufactured, but otherwise, just the shape, the design, that's not patentable. But you could look at, trademarking the name of the company or, even looking at the an industrial design, but most likely not. Like it just depends on what exactly you want to protect.
Okay,
Yeah.
thank you.
And there's always, I would look to, there's agencies in the community. I'm sure that you work closely with them. Regional Business Center, they often bring in, experts in this area who can speak to the topic better than I can. NORCAT as well. And keep an eye out. Like at Laurentian, we have activities happening on campus. We have the Jim Fielding Innovation and Commercialization Space.
Mhm.
And, we have programming available through the Foundry. So if anybody, wants to know more about what we offer, and I'll just drop our email address in
Okay.
the chat. So Foundry at Laurentian.ca. That's the Foundry is the name of our programming at the university, and Anastasia Chartrand is our coordinator. Feel free to reach out. We have resources, we have speakers, we have a makerspace that we've made available to individuals in the community, right? We have great resources there, but Sudbury is very, lucky between NOBEEP and Regional Business Center and NORCAT and Cambrian College and Collège Boreal. We have so many resources, and your partners and Karine and Gina, at NOBEEP can help you connect with those resources.
Yeah. Any more questions? If you still have questions, you can just send them to me or okay. Okay, go ahead.
Excellent.
Okay, thank you
Fantastic.
again. Yeah, thank you again, Giselle. And we'll be if you can send us the resources that you talk
Will do.
about. Yes, and I will share them with the entrepreneur. Okay, and if you have any follow-up question, you can send them to me, and I will share them with Giselle. And before we close, I just want to say that it was a pleasure, Giselle, to have you with us, and the replay will be available on the website or the YouTube channel, the YouTube channel. And I wish you all a very good afternoon. Thank you. Bye.